search, seizure, arrest, and reasonableness correlating to privacy. Definition of terms. Search. A search is any lawful action by a law enforcement officer aimed at obtaining or recovering evidence of crime from a potential suspect. There are two forms of searches, with and without a warrant. The former refers to a search conducted under the full authority of a magistrate through issuing a search warrant and upon proof of probable cause by a police officer. The latter is a search conducted without an official search warrant. The Fourth Amendment of the U.S. Constitution prohibits the search of premises, houses, and persons without an official search warrant and considers evidence recovered through such search as void at law. A police officer can carry out a search without a warrant if the search leads to the discovery of evidence of a crime. Seizure. A seizure is an act of depriving an individual of their freedom to liberty by temporarily detaining them against their will. This process involves taking property or other personal effects believed to be articles of crime from a suspect. A police officer can conduct a seizure by either using force or by demonstrating his authority through commands. A seizure does not arise under the Fourth Amendment if a person voluntarily consents or permits a police officer to interrogate them concerning a crime. A police officer intending to conduct a seizure should ensure that it contains all particulars of an accused as well as the materials to be confiscated. Arrest. An arrest is any act by a law enforcement officer that leads to the detention of an individual. It is done when a police officer believes that the person arrested has committed a crime. An arrested person is taken to a court of law and charged with the relevant offense within a reasonable time. An arrest is made by touching or handcuffing a suspect or by demonstrating any act suggesting the intention to take an individual into custody. To secure a lawful arrest, a police officer takes an oath confirming the culpability of an offense, demonstrating probable cause as well as securing actual service of a warrant. The Watson v. United States ruling provides circumstances under which an arrest can be conducted without a warrant. It is done under the following instances. When an offense categorized as a felony is done in the presence of a police officer. When an offense categorized as a felony is done in view of a magistrate and an officer is ordered to arrest. When a felony is committed in the presence of an officer and the offender is about to escape. Reasonableness. Reasonableness generally describes what is expected of a reasonable man in responding to an issue or circumstances. A police officer uses this ability to detect crime and make arrests without a warrant. It is ascertained by balancing and weighing the prevailing circumstances in crime detection against the ladder of law or national interest. It is simply those factors that a police officer has to consider before conducting a search or seizure without a warrant. A recent decision in the U.S. Supreme Court stipulates that police officers have to demonstrate reasonable suspicion before they can conduct a search or seizure without a warrant. Effect of search, seizure, arrest, and reasonableness on privacy. Generally speaking, an arrest or seizure immediately denies a person the right to enjoy freedom freely. Under the U.S. Fourth Amendment, an individual has a right to be guaranteed privacy from interference by the government. This right is only achieved when a search or seizure is done with a warrant. It also renders void and unenforceable any evidence that is obtained from an illegal search, seizure, or arrest. Searches, seizures, and arrests in general affect or violate an individual's right to privacy, especially if they are done in contravention of the law. A test that is used to ascertain whether there has been a breach of the right to privacy is whether a person has a reasonable expectation of privacy or whether an alleged breach is one that society would consider private. A search on a person's body interferes with one's right to free enjoyment of freedom, and subjection to unnecessary body searches lowers one's esteem in a society. The concept of stop and frisk. A stop and frisk basically involves restraining a person for the purpose of being searched. A police officer can stop and frisk a person upon reasonable suspicion that he has in his possession dangerous items of crime. Under the Fourth Amendment of the U.S. Constitution, a police officer has to demonstrate reasonable cause before temporarily detaining a person. A police action in determining suspicion should be reasonable to suit circumstances necessitating the detention. A normal stop-and-frisk search involves touching the outer clothing of a suspect, use of metal detectors, or sniffing dogs. The rule on stop-and-frisk is an illustration of the case of Terry v. Ohio. Automobile search. A search on an automobile is done at highway stops and is governed by a rule called reduced expectancy. In Caroll v. United States, an underlying principle is that vehicles fall under a different category of private property that requires less privacy protection compared to other types of property. Generally, the inside articles of a vehicle can easily be moved in and out, and law enforcement officials do not necessarily require a warrant to conduct a search. Searches on automobiles without a warrant are acceptable since citizens have a lesser expectation of privacy in vehicles than in their homesteads. The rule in Caroll's case allows police not only to search a vehicle but even its contents. Border searches and regulation. There are generally two kinds of border searches: routine and non-routine border searches. A routine border search is conducted without requiring a police officer to demonstrate reasonable suspicion, probable cause, or warrant of search. A police officer working on a routine basis can search a person without a warrant. Such kind of a search does not cause much invasion of privacy. The realistic expectation of privacy at the border of an individual is lesser than in interior parts of a country, since most travelers are aware of mandatory searches at borders. A non-routine border search is done in complex cases when there is suspicion of smuggling. It may involve taking X-ray photos, detentions on suspicion, cavity searches, and cargo scanning. In conducting this category of search, a police officer has to establish reasonable suspicion before searching and detaining an individual.